Hey everybody, Darren from the White Hatter, and welcome to today's Thinkable Thursday. And I've been looking forward to this interview. I found myself a legal scholar, an expert in the area of everything to do with privacy, the internet, social media, and the law here in Canada. His name is David Fraser, and we're going to be talking to him next. So let's bring him into screen. There he is right there, David. And yes, he is from Canada. He's from Halifax, Nova Scotia. A lot of people don't know this. I was born and raised there for 10 years. I'm a fellow Blue Noser. So let's bring him into screen. Good morning from the West Coast, David. I guess it's the afternoon there on the East Coast. How are you today?
I'm very well, thank you. How are you?
I am great. I am so thankful and honored that you accepted my invitation for the interview today. Can you maybe share with everybody about who you are, what your background is, and how did you get involved in this very interesting field of law?
Sure. Yeah, no, I'm a partner with a law firm called McGinnis Cooper. It's one of the top 20 in terms of size law firms in Canada, headquartered in Halifax. I had always had very strong nerdish, geekish tendencies, early adopter to technology on the internet from the very beginning back before when it was kind of Gopher and things like that. Right. Introduced actually at UBC, given a UNXG account there, and just fascinated by what was happening with society and technology and society, kind of the collision between the two, and where that friction really happens and takes place is in the area of law. Yeah. And so went to law school, did an undergrad at UBC, went to law school here in Nova Scotia. Always knew that I wanted to focus on law and technology. Mainly internet law, and discovered that that's something I could do from Little Halifax, Nova Scotia. And so most of my practice, I describe it as internet and privacy law, which are two kind of significantly overlapping kind of circles in a Venn diagram. And so do work for a large number of internet-based companies dealing with all sorts of issues from the technical kind of software sort of side and infrastructure. Although the most interesting stuff is the stuff that involves people. And so dealing with online mischief, dealing with claims of defamation, invasions of privacy, what's conventionally called cyberbullying and things like that. So I've been practicing in this area for about 20 years. It's not an area that's going to go away. The impact of technology on society, we're only just kind of seeing the beginnings of it. We're seeing significant new things as social media has become such an important part of people's lives. Yeah. And I tend to think I'm amazed at the wonderful things that technology can do, and I'm appalled at the horrible things that people can do using technology. And so this is to me, I find it just a very interesting area to talk about and to think about and to practice in, because it's not just tech, it's tech and people. It's people and tech colliding. And seeing the wonderful things they can make and seeing the incredibly destructive things that can happen as well.
Wow. Obviously, this is a fairly new field in law. And as a result of that, are there a lot of lawyers in Canada that have this kind of specialty like you, or is it kind of a fairly narrow stream?
It's a fairly small bar in a significant way, but it's one that's growing. So I was quite lucky in my timing. So I started practicing in 2001. That's when I was called to the bar. And that was the year that our private sector privacy law came into effect. Mm-hmm. And there were a number of lawyers who were practicing in the area of privacy, but generally advising governments, because the Privacy Act and FOIPOP and FIPA and all that have been around for a while before that. But I started with a very strong interest in privacy at a kind of a corporate law firm. And one of the few people that seemed to kind of leap forward and say, look, this is something that I'm interested in, something that I can do. And so I actually started in 2004 the Canadian Privacy Law blog, which was part of, so I was starting to see more and more legal bloggers out there who were engaging in a dialogue. It didn't matter where you were, you could kind of contribute to the conversation and people would respond to it, which was one of those great things about technology, because here I am sitting on the waterfront in Halifax, having conversations with lawyers who are practicing in my field in Toronto and San Francisco, in London and Paris, thanks to the internet. And I guess as a result, people who are looking for specialized advice use their favorite search engine and are looking for the right person. And so it doesn't matter kind of where their desk is. Yeah. And so I ended up doing work for companies around the world and some really interesting work for individuals Although most of my practice is kind of advising companies, the service providers, rather than the individuals.
You know, what's interesting is we do a lot of presentations at high schools, and kids are always asking us, you know, where is the industry going with regards to social media? And we talk about coding and you know, promote those type of things. But this field really interests me as well. So what kind of a message would you have for a teen who's watching this? Because we get teens that watch this as well.
Yeah.
Just based upon what you just said there, would be of huge interest to them to get into this field of law.
There are huge opportunities, and so all the big internet companies that I work with have loads of lawyers who practice internet law. There's a whole kind of practice area called product counsel, where you're embedded with a product team developing a product or working on a product, and you become the subject matter expert in the product itself. And technically, so you have to have some technical chops, but you don't have to have a computer science degree.
Right.
And then you're the guy or the woman who is there to counsel them on the legal issues. And so that's a growing field, and there's quite a few of them. We also have, and this is a kind of an exploding field that relates to kind of user trust and safety. And in fact, there's a new association that's been developed for people whose legal practices or who otherwise work on trust and safety issues. Kind of how can these platforms be abused? How do we deal with issues of content moderation? How do we deal with how do we decide what we take down, what we keep up? And kind of as these, you just think of the vast quantity of content that is put on YouTube every day. And then you think of Instagram, and then you think of Facebook, and you think of Twitter. And there are people in the background whose job it is to be the deciders about does this cross our lines in terms of our community standards. But the volume is just so huge that it's pretty difficult to keep up to. But it absolutely is a growing field. For those who are interested in the technology, there's no doubt there's a huge amount of kind of coding opportunities across the board. Yeah. But if you're interested in the human side of it and the human impact and the legal impact, there's just a never-ending, I think, kind of growing opportunity for work in that area.
So David, just for the teens that are watching, even their parents, is it like medical school where you go and get your basic MD, and then from there you can go and specialize? So for the legal field, is it the same thing? You just go and get your LLB, and then all of a sudden from there, once you got your basics, then you can spring off into what specific area you're looking to specialize in?
Yeah, so I was lucky in that I knew the sort of law that I wanted to practice when I went into law school. And I went to Dalhousie, which is now the Schulich School of Law. And Dalhousie at the time, and most law schools now, have courses in law and technology, internet and media law, privacy law. And I tend to tell people that if you're starting law school, kind of sample as widely from the buffet as possible, because you never know what. Like there's just so much in law that you might find you had no interest in taxes beforehand, but kind of once if you have a really good tax teacher who can make it exciting, that might actually be the area that you want to go into. But a number of law schools are quite well known for their law and technology programs. University of Ottawa, in particular, has a great program, super strong faculty. Osgood does as well. The Schulich School of Law does with the Law and Technology Institute here. And so certainly there are the options and the opportunities to focus. Although one of the things that I found is that I took all the internet law courses I could, but also took a broad range of like tax and corporate and all of those just become part of the foundation that you build upon in order to kind of get there. And I often think of myself as pretty multidisciplinary. Yeah. There are quite a few people who are technology lawyers who focus on, for example, the venture capital stuff for technology companies. And there are others who focus on kind of software license agreements, and those who focus on kind of trademarks and domain name sorts of things. And I do all of those, or I have done all of those. But I'm more interested in kind of the holistic, the big picture, and more the human side of things. But the opportunities are there, and they're just growing.
You know, it's funny you bring this up because Brandon just finished his master's in the area of social media communicational technology. He was thinking about going for his PhD, but for the past couple of years now, he's been talking about, Dad, maybe I want to go to law school now to kind of specialize in that area from a more of a holistic approach, right? Because I'll tell you something, he'd be a good lawyer. I just, having dealt with lawyers most of my career, I think he'd be really good. But again, it's that struggle. Do I get my PhD, which opens up more doors academically, or but it's really interesting. And this is something that I'm now going to talk to in my presentations, thanks to you now, that when I'm talking about opportunities for kids, not only am I going to be talking about the coding opportunities, but I'm now going to be using you as a really good example of how there are opportunities, if you're interested in law, how you can specialize in this area. So why don't we get to the questions right away?
Sure.
So the first question I have for you, and here it is. You've pinned to the top of your Twitter feed a torrent of lawsuits are descending on Canadians accused of online file sharing. If you get one of these, it can't be ignored. You're actually being sued for copyright infringements. So can you share why you posted this? And I just noted on your Twitter feed today, you kind of did a rebroadcast of that posting, right? Like, why is this important?
Yeah. Well, it represents something, I guess, that's relatively new, or at least the explosion of it is relatively recent. We've heard for quite some time about lawsuits in the United States related to file sharing. People use a number of different technologies, but BitTorrent is the number one, where they've been sued, and people, you get a grandmother who's getting sued because her grandchild might have been there on March break and had used her internet connection and things like that. We've had some developments in the law and developments in practice in the last number of years in Canada that put in place something called a notice and notice system, where if you're downloading movies or television shows using something called BitTorrent, while you are downloading that content, you're also making it available, which means that your internet protocol address for your computer, or at least for your home router, can be detected. And so the movie studios hire companies that do nothing but try to find people who are downloading, but also means they're simultaneously uploading content. And amendments to our Copyright Act allow them to give a notice to your internet service provider, requiring them to hand over the notice to the end user. Now, they don't know who that end user is. They just have an IP address. And they say, look, whoever had IP address 1.2.3.4, fictional address, on this particular date, send them this notice. And it's supposed to create a deterrence. And now, at the same time, the internet service provider has to keep the customer name and address associated with that in the event that the rights holder, so the Hollywood studio, comes back with a court order requiring them to hand over that name. And so what happens, and what they've been doing, at least what they say that they've been doing, if they detect people who do it multiple occasions, they will go to court and they will start a lawsuit on behalf of the production company, naming John Doe's 1 through whatever, 3,500. Because they have a list of 3,500 IP addresses. They don't know who they are, but they believe that these IP addresses are associated with uploading, so making available this content, not just personal or private copying, but making it available. And they can get an order from the federal court requiring the internet service provider to hand over that customer name and address. And then all of a sudden, John Doe becomes a real person. And so they've started these lawsuits naming multiple defendants, up to 3,500 in one case, and they get a statement of claim from the court, and they send it by registered mail. And so instead of, compared to what was usually kind of just before the warning, kind of, hey, cut this out, and previously there had been some extortionate warnings that were kind of, we found you, we're going to sue you, come go to this website and settle it, which they're not allowed to do anymore. But if you receive by registered mail one of these documents from the federal court, now it'll come from a law firm in Toronto, but they're federal court documents. That means you are in fact being sued.
Wow.
You might have a defense because, for example, in my house, my name is on our internet bill. So our internet service provider would name me, but I've got kids who live in my house who might be involved in that. And so there might be some defenses. There's questions as to whether or not I am responsible for what happens on my internet connection. I've certainly heard from, anyway, so they've sent out hundreds, if not thousands of these. And if you ignore them, so you have to file a defense within 30 days. If you ignore them, the plaintiff, the Hollywood studio, can get default judgment against you, which means that whatever they were asking for, which is usually in the neighborhood of about $5,000, is what they're going to get. And so they can garnish your income and things like that. So this has all of a sudden gone from kind of finger wagging notices to actual lawsuits. And so I started getting a whole bunch of phone calls and emails from people who were receiving these, who initially thought they were bogus.
Yeah.
And so we have within our firm, we've set up a group of junior lawyers, so it's more economical, who have been handling these on behalf of clients and people who have reached out to us. And because it's in the federal court, we can do it nationally. So the retweet of it was that everything seemed to go quiet during the pandemic. No new ones seemed to have been going out, but I got 2 calls yesterday from people who got them yesterday by registered mail, and so there's a whole new torrent of them that I think have been unleashed as that Toronto law firm has gotten back to work after the pandemic.
So let me give you a hypothetical here. Like, this is what I get from the students all the time. Is it illegal for a student or a teen or anybody to download a movie for free that they should be paying for if the movie is not redistributed via the torrent? So in other words, if I download it and just keep it on my computer for me only, nobody else, is it illegal?
Yes. Yeah. That is a violation of the Copyright Act. There are some obscure private copying exceptions that could exist. So if your buddy has a DVD of it, and this actually might have changed, so I might be actually out of date. If your buddy has a DVD and you rip a copy of that DVD, in the same way that used to kind of borrow CDs from your friend and copy them onto a cassette back in the olden days.
We're boomers.
That's right. But if I recall correctly, if the copy comes from an illegally obtained original, then it's not a legit copy, and you can't take advantage of that personal use. So, but the risk is relatively low if you're just kind of downloading. Right. If you're using a streaming service, for example, one of these illicit streaming services, simply because you're not broadcasting your IP address around. Right. And also torrenting is a protocol, as I said, where you're actually at the same time as you're downloading it, you're also sharing it. And so making copyrighted content available to the public is a more significant, in the grand scheme of things, infringement than making a private copy for yourself.
And this doesn't apply to movies. This also applies to music as well, correct?
It does, and also books. That ebooks are kind of significantly, I guess through kind of sharing platforms and otherwise. Because it's relatively one of the significant things is, and this is the impact of technology, is that once you create a digital copy of something, you can copy that 1 million times. Yeah. And that's like back in the days, like I remember when I was in law school, kind of standing at the photocopier because I couldn't afford a particular textbook, and copying entire chapters, and it took a lot of time to do that. Yeah. But these days, that one copy at the photocopier can take a fair amount of time, but I put those pages into a scanner, and before you know it, you've scanned 100 pages to a PDF, and you can easily email that to your buddy. And so the technology all of a sudden has made this possible. And also 20 years ago, if you were sharing a 3 megabyte file, that's the sort of thing that you would set up before you went to bed, because it would take that long on dial-up to download. Now
what's dial-up?
It's down like that. Yeah.
It's interesting. I mean, although I've been retired from law enforcement for 4 years, I'm a licensed online investigator here in BC, and technology is now catching up on how to track people who are trying to hide their IPs as well, right? Yeah. So this is an important topic, and I'm very happy that you're pushing it, and we're going to repost it today on all our social media platforms because of your posting, because I think that this needs to be a real awakening. Now, are you aware of successful judgments against Canadians now?
Yeah, so here's the interesting thing. So I think the economics of it, and I haven't had a conversation with the Hollywood steward on the other side, but we should kind of know the lawyers involved. So they're seeking statutory damages, which are relatively low. So $5,000. If you wanted to defend in the federal court with a lawyer one of these lawsuits, it would cost you more than $5,000. So I think that they're counting on the economics of it, and we negotiate settlements on behalf of a large number of them. And some of them we've said, like, come and get us. We have a defense and come and do that. But very few of these have actually gone to trial. And I think it's actually not in their economic interest to have these go to trial as well, because they're using very expensive Toronto lawyers too.
There you go.
But I think the economics is to try to push through as many settlements as they can. I'm actually surprised that they haven't tried to bring more publicity to this, because one would think if your objective is to stop people from downloading and uploading using BitTorrent, the more people hear about these lawsuits, the less likely they are to do it. So people reach out to me and say, well, I got one of these notices from my internet service provider. It wasn't the registered mail from the court. What should I do? And it's like, well, cut it out. don't do that.
Yeah.
And so in the same way that the Hollywood studios go and get an order connecting an IP address with an individual, that's exactly the same tool that law enforcement uses with production orders.
Yep.
It's very few people, a whole lot of people imagine they're anonymous online. No, they're not. They're pseudonymous online.
That's right.
One can usually, in most cases, connect the dots. And it's also been my experience that generally, and maybe it's just the bad guys that I have the opportunity to go after, most of them are too stupid to realize or to do the things that one could do in order to properly kind of obscure your address.
I've always said this in law
and your
enforcement.
identity.
We always catch the dumb ones. We really do, right?
Yep.
But you know what? Even the smart ones sometimes will make mistakes, right? And it's the mistake that they finally get caught up on. But next question I have for you is, schools, out of necessity because of COVID, have moved to online distance learning. What kinds of legal challenges does this pose specific to Canadian privacy law? What if a teacher sees something in the home that is concerning to them? Should they be letting somebody know? And this is a question that has been asked to me of a lot of teachers because they've all moved to online learning, right? Distance learning.
Yep.
Well, the issue is that these things are in people's homes. They're not being set up properly to give privacy. And now all of a sudden, teachers can be seeing things going on in the home that are very concerning, but they're asking me, am I under a duty of care right now to report what it is I'm seeing? So, thoughts?
Yeah, so privacy laws haven't gone out of the window because of COVID, and privacy has probably become a little bit more of an acute concern in some areas, and it is one of those areas where there's friction. There's no doubt. Kind of online test taking software that kind of tracks your eyes and things like that.
We're going to talk about that one next.
Don't want to give it away. Spoiler alert. But so certainly having children do online learning with a webcam brings the teacher into the kid's house in a way that was never really contemplated. And we have had cases kind of pre-COVID where school supplied laptops, for example, had essentially kind of spyware on them, and they could activate the camera remotely, where a whole lot of kind of malevolent and mischievous things were being done using that technology. But I think what you're asking about is kind of the teachers, their online instruction, group of kids see something in the background that's problematic. The teacher always has, in every jurisdiction in Canada, has legal obligations with respect to student privacy. And so just to kind of put it in the thumbnail, you can only use information that's collected for the purposes for which it was collected, or for a compatible purpose. But there's often an exception that deals with for law enforcement or when it relates to individual health and safety. And also teachers need to be mindful, and frankly anybody in a circumstance like that, because it's usually the case in most provinces, but it's particularly acute for professionals, for doctors, teachers, nurses, lawyers, to understand what the law is with respect to the duty to notify. For example, if you're aware of a child in need of protection, so you see evidence of abuse, physical, psychological, sexual, in connection with that, you might have a legal duty to notify, and who you notify is going to vary from province to province. Could be Child Protective Services, could be the police. If it relates to sexual abuse and child sexual abuse materials, it's probably the police, and that's maybe a different statute. And so teachers need to, I think, simply be aware of this. And also, I think that school boards and others need to provide resources to teachers so that they're not kind of on their own making these sorts of decisions, because it's a very difficult spot to be in.
Yeah.
And also, there are, in fact, some differing interpretations of these laws. And so I've been involved in cases where you have a professional who's subject to privacy laws that have to keep everything confidential, not disclose it to anybody unless they're legally required to. And the provincial statute simply says to report. And so how detailed do you get into that report? It's not to investigate and kind of provide the whole file. It's to report. And so you do end up with this sort of tension. And I would also be aware of or mindful of just the difficulty that one might have of imputing too much meaning into something that you see, or and not doing a follow-up. So if you saw something that was problematic, you probably want, and you're a teacher, you'd want to have a one-on-one with that student to the extent that you could, in order to really suss out, is there an issue, or was the yelling in the background just their 3-year-old sister who was having a really, really bad day, or something else like that.
Just on that, David, there was a case just last week where teachers were doing this, and they were talking to the kids in the classroom, and the teacher saw what appeared to be a rifle hanging on the wall and behind the room. She reports it to the police. The police now get involved, and turned out it was a Nerf gun. Right, so this context thing is important, but teachers are constantly asking me, Darren, what is my duty? So what I just heard you basically say, listen, if it's specific to body and life, i.e., sexual, yes, but on some of these other things, you got to be careful, right?
Yeah, absolutely, and so in a circumstance like that, I think probably the prudent thing to do for the teachers to reach out to the parents.
Yes,
and say, look, what I'm concerned that appeared to be a firearm, that if it's a firearm, it's not properly or safely stored. Say, well, it's a Nerf gun, or it's a disabled antique, or I got it at kind of a gift shop in West Virginia when doing this kind of Civil War battle tour, or something else like that sort of thing. I've known of people who have been kind of arrested because a process server, a cop shows up at the front door and sees what appears to be a gun over the mantle, arrests the person on the spot. And ultimately, it's determined that it's not even a replica. It's not even a good replica.
Yeah.
So that sort of thing. But there are things that would obviously be concerning to a whole lot of people that aren't illegal, like just not good living conditions. They're getting a window into. I have a friend who's a teacher in Ontario, and during this last lockdown, a number of his kids he was trying to teach them online, and they were living in shelters.
Yeah.
And so a difficult environment in which to live. So I think we need to be mindful of this. And I always try to kind of keep in the back of my head kind of the fundamental humanity of people. And while one wants to, you're sometimes seeing the really worst in some people, kind of start out kind of assuming the good faith and the best, and asking questions is a prudent thing to do, rather than jumping to conclusions. Yeah. Because you never, so you think that's a gun, you call the cops discover something else in the house that's, it may be somebody's on condition, who knows, but is it really in the best interest of the child to make that determination? I think in many cases that needs to be the first question to be asked.
Your answers thus far, especially this last one, I think is a really good example why I'm so excited to have you on here, right? Because you're able to take, it's much like the doctors and the PhDs I talked to. I'm very much attracted to doctors and PhDs who can take academia and put it into plain English with a humanistic factor attached to it. And you're doing the same thing now from a legal perspective. And this is why I was so attracted to you, especially because of what you say and do on Twitter. But next question, you kind of hinted to this already. Here's the question. Just recently, University of Ottawa Students Association went public about how their university is using AI software to help detect cheating. Their concern is, what is the university and the company they contracted with, which is US-based, doing with this data, and where is it being stored? Let's hear your thoughts on this one. This is a good one. I'm actually in support of the Students Association. That's me personally. What about you?
Yeah, well, I think I largely am. And one of the things that's just so interesting about this area of law is that it's not overly prescriptive. It's based on kind of essentially what is reasonable in the circumstances. So a university, not to single out University of Ottawa, but a university can collect information, personal information from students without consent, because public sector privacy laws are not consent-based, as long as it's reasonable. And Can
you just repeat that again, what you just said?
Yeah, so our public sector privacy laws, the ones that govern government, municipalities, universities, schools, and hospitals, aren't based on consent. It's not like going to the bank where you sign a privacy policy and all that sort of stuff. It's based on what's reasonable. Like, is it reasonably necessary for a legitimate operating program of the university to collect this information? And if the answer is yes, then they can collect it. And they can only use it for those purposes, or for purposes that are reasonably related to it. So the interesting discussion is in whether it's reasonable and proportionate. is it reasonable to assume that you have to supervise students to such an extent to prevent cheating that they have to be micromanaged on an individual student basis? And then, obviously, where they're not going to be in a classroom, is it reasonable to use technology to do that? And then, and this is one of the great interesting conversations about technology. It's not that the person has to do the exam. Like my son did some of his exams sitting with his webcam on Zoom. Everybody else was on Zoom, and the teacher could see. So you weren't consulting with other books and stuff like that, which was pretty akin to the normal practice in a classroom.
Right.
But what's being proposed is a technology that replaces the teacher or the proctor or the invigilator, whatever you want to call them, right, and replaces it with some sort of artificial intelligence that is somehow scanning or analyzing you and then making decisions about you and reporting you, narking you out to your prof or something like that, where there's probably going to be an assumption that because the computer said you might be cheating, is that there would be an assumption that you were cheating.
Yeah. Just on that, David, I mean, a good example is what if the student has ADHD? I mean, where the AI can't it's not to the point where it can make that put context into that, right?
Yep. Yeah, no, absolutely. And so artificial intelligence is only as good as the model that it's based on.
Yes.
And so if it doesn't take into account kids with ADHD, it doesn't take into account, I might be somebody who, like, when I think about an answer, maybe I stare up at the ceiling.
Yeah.
And formulate my answer. And then there are going to be others who kind of outline it, who kind of sketch it out. And so there's always going to be issues when you use automated tools to either make actual decisions or to inform decisions. And we need to make sure that those tools are right and are not unfairly used. And it's the same sort of questions that come up with respect to facial recognition.
Yeah.
The kind of if you put facial recognition on a downtown street, and the cops can say, oh, well, we're going to compare it against the database of mugshots and bad guys. Well, they're not accurate enough. And so if I look like I can, certainly I've heard from dozens of people who have similar enough names and birth dates that they have a hell of a time going through customs. There's a whole lot of people who look familiar. And so all of a sudden the ERT kind of comes swarming in because they think it's kind of the FBI's most wanted.
Yeah.
But it's just some guy who happens to look like him. We need to be very mindful about automated tools that make these sorts of decisions. And I think also in some cases and I'm not going to point fingers at the University of Ottawa in particular, but they're a bit of snake oil. That some company says, hey, we have a solution and we can fix this problem. And you're taking the human out of it. And I've sometimes thought of it the police want to put cameras in public places. Well, somebody has told them that that's a solution that means you don't actually have to have police officers walking down the street mm-hmm. and engaging with the community. Mm-hmm. It kind of saves money, but really it doesn't actually save a significant amount of money. And then there's the whole additional thing that it could be stored in the U.S.
That's my next question. Isn't the bigger question as well? I agree with everything you said there. In fact, there's been a couple of cases now in the U.S. where individuals have been arrested based upon AI face identification and they weren't the person, right? But now the bigger question, because Canada is one of the leaders when it comes to understanding keep it data in our country with some exceptions, right? And, primarily because of that Patriot Act in the United States. So isn't a question here as well is what is U of O doing with the data? Like where is it being stored, how it's being stored, who has access to it?
Yeah, well, the bigger question is what is their contractor doing with it?
Yes.
Because U of O, we know what rules U of O is subject to. And so a not insignificant amount of my practice deals with kind of cross-border data transfers and issues like this. So the only legal impediments that exist to cross-border data transfers in Canada are actually the public sector privacy laws of British Columbia and Nova Scotia.
Yeah.
No other jurisdiction kind of prohibits cross-border data transfers. Most other provinces require and federally require essentially a privacy impact assessment to say, look, what impact does jurisdiction have on the privacy, security, and integrity of this particular information? And the fact that this information is being stored in the U.S., that actually doesn't concern me a whole lot, given the nature of the information.
Right.
It's not. So a whole lot of people imagine that the USA Patriot Act has created this massive data vacuum to hoover up massive amounts of information. And most of the hoovering that was happening was actually illegal, was the U.S. National Security Agency kind of hacking into backbones and stuff like that,
Yeah.
or eavesdropping on international connection points, which is something that Canada does as well. Like that's
Right.
we have an NSA, we have a Patriot Act. Most people don't know that. But in this sort of situation, I was asking, what's the nature of the information? And is it something that actually would be of interest to law enforcement? And so, what a whole bunch of English 101 students in Ottawa look like, or how their eyes twitch when they're writing their essays, is probably not of interest to anybody, frankly, other than somebody who wants to create a model on what students look like when they're cheating or not cheating. Now, if it was registration information for the university, I would be a little bit more concerned. One example that I sometimes give, so if I went out on my own and was kind of starting a law firm from scratch, I would use cloud-based tools. There's no doubt about that. If I was a lawyer with an immigration practice dealing with, for example, security certificates and those sorts of things, I would never put my data in the cloud. Because that's the sort of information about people who might have ties to terrorism or that whole area. That is information that is of interest to law enforcement and others. But information about kind of a grade 6 student's marks at an elementary school in Kelowna, they don't care. Mm-hmm. Canadian law enforcement don't care about that, and American law enforcement would care even less. And so that needs to go into the analysis. But there's also, what are the policies? What are the rules? What are the contracts around it? Is the data encrypted? Is it tokenized? There are a whole lot of kind of technology things that also can come into play. And
is a concern, David, sorry to interrupt, is a concern as well, though, if they're collecting facial recognition, is there a concern there that the vendor who's selling this stuff could be taking that facial recognition of that person and then providing it or giving it to law enforcement?
Well, so it depends. And so you end up, and so this is why one always needs to have a really deep dive into kind of, well, what's going on? What's the nature of the data? Because there's an important distinction between facial recognition and facial detection. And so if they're doing analysis to try to determine whether or not somebody's cheating by kind of, are they looking over at what could be a book next to their desk or something else like that, you don't care who it is. You just care what the shape is and what the shape is. So you're detecting a face. Mm-hmm. Doesn't matter if it's David's face or Darren's face or Bob's face or whatever. And so it's just detecting that it is a face and it's making kind of suspicious movements. Mm-hmm. And so that is less problematic than kind of creating a face template that could then go into some surveillance system. And so it requires that sort of time, in the same way that we've seen on well, just about it, and anything and one of the things that I'm grateful for, most large organizations like universities, and I would expect the University of Ottawa is the same, have privacy officers, have lawyers, should put anything like this through something called a privacy impact assessment, mm-hmm. which is simply a tool, a filter to make sure that you recognize and have surfaced all of the privacy issues, and you have the opportunity to kind of push them back and to mitigate those issues. Or if they can't be mitigated, then you have a picture of the whole project at the end of the day to be able to say go or no go. So, for example, if it did take pictures of faces but didn't need to, all it needed to do was to detect kind of patterns of eye movement, for example. Well, then you tell them, don't take pictures of faces. You don't need to do that. And then once you've done that, then it's a matter of kind of calibrating the whole service appropriately. And there's a whole area of something called privacy by design, which former Information Privacy Commissioner of Ontario, Ann Cavoukian, kind of pioneered, which is to build privacy into your products from day one.
Yes.
Which is kind of highlights, it gets back to an earlier point of kind of bringing the privacy people and kind of the social sciences people into the same room with the technologists while our technologies are being developed, so that we're not losing sight of the humans that are going to be using it and the impacts that these sorts of things might have on the individual users, but also on society as a whole.
I mean, it's kind of like medicine. Medicine is very siloed, right? Like ER docs don't talk to cardiologists, that don't talk to respirologists. I mean, the same thing, what you're talking about is more of that holistic approach. Like, you do not know how much I'm enjoying this conversation right now. Like, I am really enjoying it. Next question I have for you. To increase privacy, many social media platforms are moving to an end-to-end encryption. This move, however, comes with controversy, especially when it comes to the criminal element taking advantage of this move. What are your thoughts? Is it all or nothing, or can there be a balance that allows law enforcement access without a court order? I mean, a good example, I use the app called Signal. I mean, very, I'm sure you're familiar with it, right? But with that, we now know that the criminal element is moving to technology like this. And I mean, the big thing right now, Facebook is looking to move to end-to-end encryption for everything. And one of the concerns that child protection advocates have right now is the issue, well, how are we now going to detect when these predators are online doing what it is they do? Shouldn't we be allowing a backdoor? Thoughts?
Yeah, and certainly it's an interesting issue, and one that I've followed for quite some time. And one thing that, when you look at it in a broader context, I tend to think of it as a bit of a self-inflicted wound. The complaints by law enforcement about going dark, law enforcement and national security folks, because the reason why things are going dark is because of the abuse that took place and the unlawful access to unencrypted communications. And frankly, if you think about kind of what kicked off a whole lot of the desire to go end-to-end encrypted, it was Snowden. And it was Edward Snowden revealing mischief that had been taking place by intelligence agencies tapping into communications, and that weren't just restricted to bad guys. So if the perception had been, oh, well, they're only tapping into the communications of people who are reasonably suspected of committing crimes, most people would probably just shrug that off. But what was reported is trying to get access to massive amounts of information about individuals who are not involved in any criminality whatsoever. And that creates a fair amount of pressure to do that. And
just before you go on, I just want to say this, full disclosure, as an ex-cop, I totally support what you're saying, right? I mean, the attitude in a lot of law enforcement agents, it may be awful, but it's not unlawful. So we'll do it until we're told not to. I mean, that's where bad case law comes from, right? I totally agree with you that law enforcement are kind of the authors of their own demise on this issue, but continue.
Well, and also kind of related to that is in a way that they're not going dark. They're not only going dark, they're also getting buried in more data than they've ever had access to in history. And so police are getting production orders for tower dumps. In some places in Ontario, where it involves getting information about tens of thousands of people, where one person in that pile of tens of thousands of people is the one person you suspect of robbing that jewelry store, but you're getting the information about tens of thousands of other people because it's digital. And you can just kind of get an order requiring the telco to hand over the information about every customer that was within a mile with their cell phone. And in a city, that's a large number of people. They still have access to metadata, and metadata tells you as much about the communications as the content of communications. But it's a tricky area to be into. Like, the reason why Signal and Telegraph have become so popular is because people want that level of security. And the reality is that, according to every technologist that I've heard from, you cannot build in a backdoor that will not be exploited. Because we're not simply concerned about U.S. law enforcement. We're concerned about Chinese. We're concerned about India. We're concerned about Iraqi. We're concerned about, and a whole lot of really, really good hackers. You see one of the new helicopters going by?
I did. I just saw that.
Always interesting here on Halifax Harbor. And so we're concerned about an increasingly sophisticated level of bad guys that aren't just state actors, but we're also increasingly concerned about more state actors who are out there looking for information. So, like, some of the largest hacks that we've seen that have resulted in the kind of exfiltration of personal information. One of the big ones was against a U.S. government department, where information about tens of thousands, if not millions, of veterans that was taken. None of them have suffered identity theft as a result. It's because it was the Chinese government that likely took it. And everybody that I've spoken to within those platforms are really concerned about abuse on those platforms, are
Right.
really concerned about particularly child sexual abuse material
Yeah.
that might be shared on those platforms. And for certainly there have been some negative portrayals of these companies' willingness to put in place measures. Pretty well, if you take a photo and you upload it on Facebook or you put it in your Google Drive account, that photo is fingerprinted and matched against a database of known child sexual abuse imagery, like every single image. And that's just the reality. Now they do that under U.S. law, and if they find it, they'll report it to Canadian law enforcement if it's a Canadian account. The tools that they've put in place, again, going back to the number of photos that are posted every day on Instagram, the number of videos that go up on YouTube, there's no way of individually with a human being kind of moderating this sort of stuff. And the volume is just simply going to increase. And there may in fact be ways of still doing electronic checks, for example, on your device, even with end-to-end encryption. And that would be an interesting kind of technology to explore. But certainly if encryption were outlawed or backdoors were required, that would significantly compromise the security of all of our systems. Yeah. And could you put in place a rule that says, oh, well, your communications with your bank can be encrypted, but if you use Facebook Messenger or WhatsApp, it can't be encrypted? And I'm a lawyer. I'm concerned about the confidentiality of my communications with my clients, and I need to have access to secure tools.
Mm. It's an interesting. But you're right. I think you can look to law enforcement, self-inflicted wound, with the way that you said it. I mean, not just law enforcement, but agencies that have 3 letters in them: DEA, FBI. The other one's NSA. I mean, we inflicted that ourselves. Next question I have for you. This is a very topical one, in my opinion. What are your thoughts from a privacy standpoint about the COVID tracing apps that are coming to the market? And would you download one voluntarily onto your device? A good example of what's going on in Alberta right now, right, with their app. So, very topical issue. A lot of people asking me that question. I said, I don't know, but I'll ask an expert.
Yeah, and they generally kind of fall into 2 categories. One is contact tracing, and the other is exposure notification. And you can get really deep into the weeds on what the details are. But one of the fascinating things to see at the beginning of this pandemic was a whole bunch of technologists who came to the fore saying, I have this toolbox full of tools. Could it be useful for dealing with this? And Apple and Google, in a fascinating collaboration, recognizing that most smartphones are either iPhones or Android, collaborated in an unprecedented way to come up with a framework to do exposure notification.
Just before you go on, wasn't it? Can you imagine being in the room to see on that press release whose name went first? It would have been an amazing discussion. But sorry, continue.
And I've seen some interesting discussions in the privacy community talking about what that process was like, including the chief privacy officer of Google, Keith Enright, and the chief privacy person, Jane Horvath at Apple. But yeah, no, it must have been a fascinating process. Also interesting to see that kind of public health people were saying, this is what we need, and this is what we would like. And the difference between need and like had a significant privacy impact. And they said, we're going to design something for what you need, what you're telling us you need, because we don't want to be a party to more than that. So most exposure notification apps, they've decided that all the data is stored on your phone. It's never released to anybody unless you initiate it. So the individual is in control. Also, the individual chooses, of course, whether or not they're going to install it or download it or not. And so the Alberta app is more an exposure, is a contact tracing app where information can be and will be disclosed to public health to help them do conventional contact tracing. The exposure notification ones are ones where, and that's the one that's going to be rolled out nationally, where there's no record created of who you were in contact with, just your phone was somewhere nearby, some other phone. The 2 phones randomly know each other, and one can alert the other in the event of kind of pulling the switch of kind of a positive diagnosis.
Right.
Would I install one? Yeah, I would. I have parents who I'm concerned about their health. I have friends who I'm concerned about their health. If it makes it easier for us to reopen at lower risk, that makes sense. And I've also there's there's more kind of conventional contact tracing. I've had a number of clients reach out to me asking about, okay, well, we're opening our offices back up. Should we keep track of who is where when? Like, we've never before kind of done attendance in that sort of way. Should we keep track of that? And it's like, okay, well, what information are you collecting? Oh, just that. So in my office here, we have 5 floors in an office building. Our new rules for kind of gradually reopening is that you stay on your floor unless there's a reason not to. Because you just want to minimize that. But if I went to another floor, I would keep track of that in the event that I was exposed to somebody on that other floor. So there's the high tech ones, which are great, and there are the lower tech ones, which are similar sorts of issues. And the privacy hasn't, maybe anticipating further question, but privacy hasn't gone out the window because of this pandemic. It's still a matter of balancing, but the balancing is maybe in a slightly different place. We're no longer talking about things that might be convenience. We're talking about things that relate to public health. And we're being asked to do things related to a larger public good that we've never been asked to before. And so personally, I would see it kind of not my civic duty, kind of in that sort of sense, but if I can contribute in a positive way to flattening the curve, reducing spread, making it easier for public health people to do their jobs and take the burden off them, I would do what I can. I wouldn't want to impose that on others, but there does come a line where I think that mandatory mask wearing might be a reasonable thing to do. It doesn't protect the person wearing the mask; it protects the people from people wearing the mask.
Yeah, that means a lot to me coming from a privacy expert such as yourself to say to me that if an app came out that was developed by a reputable government organization, that you would download it onto your device. Yeah. Next question. You stated in a tweet, every jurisdiction that requires the mandatory collection of personal information from customers for contact tracing needs to implement strict statutory damages for the misuse of the data. Has privacy become a backseat to COVID? And just to give this some context, it was a tweet where you went into a fact where a person ran into a restaurant and the waiter at the restaurant connected with that customer via Facebook, if I'm correct.
Yeah, and don't know in the background where that connection came from or where that information came from, but sort of kind of connecting some dots. But certainly, so in some jurisdictions in Canada right now, it's mandatory for restaurants to collect contact information for people who eat indoors. Either you need a name and phone number, name and email address of one person in the group or for everybody. And the purpose for that is to facilitate contact tracing. Other places, I went to a place in Halifax last week, sat on the patio outdoors. I'm not yet ready to eat indoors, I think, but they took my name and my phone number when I went in. They didn't have to, but they've obviously decided this is what they want to do. There have been issues. So in the UK, this is required. And so it's a collection of personal information. It's not the most sensitive information in the universe, your somebody's name and phone number. But it can be misused. And it can be misused in ways that sometimes the people putting these programs together don't necessarily recognize, particularly if it's a room full of white men, which is more often than not the case. Because the example that was given that I was tweeting about was a woman who went to a restaurant, kind of name and information was given, and then was contacted out of the blue by the bartender from that restaurant on Facebook. Did he track her down using that information? If he did, that's a gross misuse of that information. We need to make sure that doesn't happen. There was a case reported out of Australia, actually just yesterday or just overnight, where somebody got a hold of contact information from a restaurant collected for contact tracing purposes and made prank calls. So pretended to be public health and pretending to kind of reach out to them because they had been exposed. And so, this sort of information can be used mischievously. It can be used quite maliciously. And so what I'm getting at it is that anytime an organization collects personal information, whether it's for their own purposes or for somebody else, they need to put in place the processes to make sure that information is kept secure, is only used for those purposes. And it's particularly challenging where you have government requiring businesses to collect information on their behalf. And this happens in the area of anti-money laundering and a whole bunch of other areas that are usually kind of way more complex and way more regulated than restaurants. Have somebody at the host table, can I get your name and your phone number, which 6 months ago they were getting that to tell you when a table was free. They would send you a text message, and now they're doing it for as a kind of an agent on behalf of government, and you can't say no. Like you could before say, no, I'm not going to give you my numbers unlisted. I'm just going to stand here and wait till the table's free, or kind of some other mechanism. Right. If it's mandatory, you don't get to say no. And so we need to make sure that that it's not misused, but also so that women can go to a restaurant and not have that information used for subsequent harassment. And so that small issue that kind of comes to the fore in a COVID context is actually it's an issue that's a much more pervasive one, but it just becomes I think gets more attention in this sort of context.
And Brandon was just whispering in my ear, that's one of the reasons on dating apps we advise women to use throwaway emails, right? So just to help make it a little bit more difficult for the purpose of being tracked. Great comments. A couple of things that you mentioned there that I never even thought about, right? And I think what's important for employees to know is that if you're taking that information, my opinion only, and then all of a sudden you're using it, say, to make those fake, hi, I'm with Health Canada, and it's false, you could be arrested and charged for mischief under the Criminal Code of Canada, right? Like there's a variety of different things that can happen there. Next question I have for you is lots of talk about the privacy concerns surrounding the app TikTok. What are your concerns, and would you download this app onto your personal device, especially if you are an adult who stores lots of personal information and professional information? But just to build upon that, I mean, any app is basically doing the same thing when the free apps, right? I think the bigger concern here is who has access to it, right? Because it's Chinese app, the state, China, has access to that information. So just some of your thoughts, because this is really kind of heated up over the past couple of weeks. I mean, to the point where a certain world leader is threatening to not allow it in their country. I know India is now banned it. Australia is now talking about it as well. So some of your thoughts.
And I think it's another one of these things that should hopefully make people think maybe a little bit more broadly about not just TikTok on their phone, but all apps on their phone. Pay close attention to whatever permissions they're demanding in order to use the app. Get a little bit more savvy about where these apps are coming from. An app from Google I would trust, an app from Apple I would trust, Microsoft I would trust. But there's a whole lot of developers that are out there. It's like, who is this person? I have no idea who they are. And we talked about kind of the location of information and potentially having an impact on privacy, because privacy laws can be very different in very different jurisdictions. And so in some cases, information can be required. So a Chinese company can be required to provide data to the Chinese government without a warrant. At least in Canada, we have a warrant requirement. So you know that there's an independent third party who's going to evaluate the request and look at it through a human rights lens. But that's not necessarily the case. But you also think about what's the data that you put on TikTok. I think probably most people using TikTok are consuming TikTok. They're just kind of watching the little funny videos, and they're not actually kind of creating stuff. So if the app doesn't have access to your photos and other personal things on your phone, that may be less of a risk. But also, like, some things get discovered. And one of the things that really brought TikTok to the fore was that Apple updated the latest version of its iOS operating system.
Clipboard.
That created an alert that would let you know when an app was monitoring your clipboard.
Yeah.
Which there are legitimate reasons why an app would do that. And TikTok said, it was so that people could easily share the URL to a TikTok with other, which might be a complete legitimate thing. But it also means that if you're using a password app for your banking app, for example, in order to remember your password, or you're cutting and pasting your banking credentials, that means that that's getting sucked up as well. And so that's not something that kind of normal people are kind of turning their mind to necessarily. So I do think that, and it's really hard to do, and it's easier to say than to do. And for somebody like me or like you who spends a lot of time thinking about this stuff, it's going to be top of mind. It's going to be thinking about kind of the diligence and also reading what other people are writing about these apps and these developers and paying attention. But I don't think everybody has the time for that. And so that's a real challenge. I think we tend to put a lot of trust in the platforms like Apple and Google to try to kind of call these things out, but we can't be protected from everything. So we need to be careful about that. And there's a podcaster and writer that I follow who likes TikTok, but she has a burner phone for it. she won't put it on the same phone as her banking app and her kind of other things like that. Not all of us have the resources to get a burner phone, but if somebody's doing that, that probably raises a flag or an alert to be mindful of.
Mm-hmm. Next question I have for you. Many of the big social media vendors' headquarters in the USA, because of this fact, often they will utilize Section 230 of the U.S. Communications Decency Act to shield themselves from financial liability. Does this apply to Canada as well? And should this section be updated or even rescinded, in your opinion?
So some people have said the Section 230 of the Communications Decency Act is the kind of what created the modern internet and allowed companies that operate platforms to flourish. And in a nutshell, what Section 230 does is it means that if you are a provider of computer services, in U.S. law, you cannot be treated as a publisher of content that was created by your users. So if that content is defamatory, the author of it could be liable for defamation, but the platform won't be. And the purpose for that is that it's to encourage companies to moderate or not moderate their content. And it was the ultimate hope was that because the case law that this came out of was an internet service provider that was found liable for its users' content because it was engaged in moderation. And the court said, if you're taking some responsibility for what your users are doing, you need to take all responsibility. And so Section 230 of the CDA changes that. We don't have that in Canada. So a platform in Canada can be found to be liable for content produced by others in defamation or otherwise, depending upon whether they knew about the content or ought to have known about the content. And so it's really circumstance specific. So it's not a bright line rule. So a U.S. provider can take comfort from the fact that under no circumstances are they going to be treated as a publisher, except copyright law and child sexual abuse materials and some narrow exceptions. In Canada, it's a little bit more nebulous. And the reality is that most of the platforms that Canadian consumers use, as you said, are headquartered in the United States. So can you sue an American platform in Canada? Yeah, you absolutely can. If there's a real and substantial connection between what happened in Canada, so there's a federal court decision that says that the Privacy Commissioner properly has jurisdiction to investigate Facebook, for example, things like that, when it deals with Canadian consumers. And there's loads of cases like that. But the reality is, if you're trying to enforce your judgment in the United States, Section 230 of the Communications Decency Act might actually prevent you from actually getting anywhere. So for the process in Canada, if there's no assets in Canada to go after, you're going after them in the States, they can be blocked. And there's, in fact, an additional blocking statute in the United States called the Speech Act, which means that you cannot enforce a non-U.S. defamation judgment in the United States against a U.S. company unless that defamation judgment took into account the U.S. First Amendment, which is pretty rare to get a Canadian court to have to opine on the First Amendment. But theoretically, if you did, if you were suing an American defendant for defamation in Canada, the prudent thing to do would be to ask the court to apply the Sullivan and New York Times standard from U.S. defamation law, and maybe you could get your judgment enforced in the U.S. And that was put in place to prevent people from engaging in something called libel tourism, where you would sue a U.S. author, for example, in England, because their book was published there, because English defamation law and Canadian defamation law has a much lower bar than in the U.S. So should it be done away with? I have kind of mixed feelings. Certainly, it has been responsible for the ability for people to share content and share great content, wonderful content. Also has provided or removed some of the incentives that might exist for policing things. And I've followed the debate very closely, particularly a couple lawyers and academics who have written a lot about how it might be used as a shield with respect to a lot of activity that is kind of misogynistic and homophobic. So beyond traditional sort of defamation. But certainly it is being discussed in the U.S. more than it ever has been. It's also being misunderstood in the U.S. more than it ever has been. But no, it'll be interesting to see where that discussion goes.
But here in Canada, if it's a Canadian-based company, i.e. Kick, Canadian-based, they can be sued in Canada successfully, and any tort associated with that can be collected by a Canadian.
Yeah, absolutely.
Wow.
And in fact, they could be sued in Canada by an American who if they sued in the U.S., the Communications Decency Act might prevent them from being successful. But they could come into Canada and sue, and the Communications Decency Act wouldn't come into play if it's a Canadian company with assets in Canada. Yeah, because very often it's not just kind of where do you sue, where's the money? Because you're not just looking to feel better that you've won a lawsuit. You're looking to get your payday, get your damages, and certainly if you're not, your lawyer probably is.
Gotcha.
So.
Next question. We're just about done. Can Canadians who are conducting themselves in less than desirable ways off the job, but caught on camera and then posted in social media, be disciplined or even terminated by their employer? Like, I hear this a lot. I do a lot of teacher education. I get a lot of teachers going, oh, you know what, Darren, what I do in my own time is my own time. I can't be held accountable. And I said, whoa, I was a cop, but I was responsible for 24/7, right? And you guys have a local parentis associated with that. But let's move outside of teachers. Let's apply this to any job. Thoughts?
Yeah, oh, absolutely. You can be disciplined and you can be terminated for out of work conduct if that conduct is prejudicial to the legitimate interests of your employer.
So there needs to be a nexus, right?
That's right. And based on the circumstances. So teachers would probably be held to a different standard, as would police officers, compared to a construction worker, because it would always be kind of really how prejudicial is this to your employer's interests, and how much does it compromise your ability to teach or your ability to be a leader in the community or what have you.
Right.
But absolutely. So we've seen, and I've seen in the last little while, in connection with Me Too and Black Lives Matter, where individuals have made social media postings that have been misogynistic or that have been racist, and those individuals have been terminated.
Yeah.
Because what happens is that person's conduct and their comments become attributed to their employer.
Right.
And the likelihood of that happening is going to depend upon the circumstances. So if they're a warehouse worker, that might be different from somebody who's a spokesperson or somebody who's an executive.
Right.
But also the reality is, and I've been asked this question what seems like forever. It's like, so you're an HR manager at a company and you're looking to hire somebody. Can you Google them? Can you look them up on social media?
That was my next question.
Yeah, and the answer is, well, it depends on what privacy law you're subject to, and it depends upon what the position is, but you probably should. Because the reality is that other than the fact that kind of we know each other on Twitter, if you were looking for David Fraser, you would Google me. That's if you're looking for my contact information, you're not going to say, oh, what law firm is he at? McGinnisCooper.com. You're just going to kind of Google the person's name. And so the reality is that people are using search engines as phone books. And whatever comes up is going to reflect upon the person who's doing it. And it's going to reflect upon their employer. And so it really does make sense. Now, in the employment context or in the kind of hiring context, you want to tell people, yes, we're going to do this.
Yeah.
Also told people who are looking for jobs, be careful about kind of what's out there, because that can reflect on you. But that is the modern reality. So if your conduct reflects poorly on your employer and it's sufficiently prejudicial, it can justify termination. Now, unions, collective agreements, all that other stuff is going to come into play. Does it merit suspension? All that. But yeah, absolutely, you can be subject to discipline for out of work conduct if it's prejudicial to your employer.
Thank you very much. Last question I have for you. With convenience of technology comes vulnerability, especially when it comes to our privacy. What do you see are some of the legal concerns you see on the horizon that we should be thinking about now? Again, I know you don't have a crystal ball, David, but obviously, I mean, given the field you're in and seeing what is developing, How would you answer that question?
Yeah, it really, it's very difficult to try to look over the horizon in an area where 5 years ago it would have been very difficult to predict kind of where we are now and what tools we're using now, and to think about, oh well, TikTok is now this huge thing, and so kind of what's going to be the issue. I think that it's going to be what we're dealing with now, but more. And it's going to be dealing with probably more use of technologies that are not just American companies. So I think the TikTok and the Chinese example is probably a beginning of what's probably going to be a larger trend of other non-North American platforms getting more traction and getting more users, and so being mindful about that. We're going to be dealing with questions related to online reputation and the right to be forgotten. So currently there's a case pending in the Federal Court of Canada that I'm co-counsel for Google on, related to delisting search results from legitimate news sites. And when I speak to kids, and I've spoken to my kids' school and other groups, I always tell people, be mindful about the data trail you're leaving behind. Mm-hmm. Because whether you're intending to or not, you are creating a digital portfolio that will be available to others. And so you talked about using a throwaway kind of email address on dating apps. Absolutely, don't use your real name on your profiles if you're under the age of 18 or even over. Do you want to be professionally associated with that? I can look on my bookshelf here and I have yearbooks from when I was in high school. I'm glad they don't exist online. Yeah. And other kind of photographs as well. And so I think that's something we're going to have to reckon with. But it will also be interesting because I've also heard from others who say, well, 15 years from now, everybody will have embarrassing things on the internet. And so whoever's going to be hiring you is going to be in exactly the same position that you are as well. And so it might actually be interesting to see, will our level of acceptance actually go up? Will our being judgy and judgmental, will that diminish?
One of the things that we're doing with the kids now is, especially in 10, 11, and 12s, we're getting them more thinking about how to leverage their social media for academic and employment opportunities, right? And using it to your advantage, and how to go about doing that. And this is important. We talk to parents about the issue of sharenting and understanding that's what's cute and funny to you as a parent today may not be to your child when all of a sudden they're in grade 8 and you posted a picture of your child when he was 3 years old in the bathtub half naked that the school bully now takes and weaponizes against them, right? So getting kids, what we're trying to get kids to understand now, privacy and security is important, but so is leveraging. We know a couple of students who've taken our course now that as a result of using the techniques that we teach them on leveraging, made them more attractive to a college, a university, or an employer because of that digital dossier that you spoke about right there. But one of the challenges I see in the legal field is same in the science. The scientific method is slow by design. Right? But the problem is a lot of this research that is taking place now in academia specific to things like screen time or whatever, it's so dated now that it has no relevance today. And I see the legal kind of field is kind of that way as well, is that, it takes time to work its way through the court system, right? Thoughts?
Well, I think that, the law represents society, but it kind of lags behind. Mm-hmm. And so that's just inherent. And that always has been inherent, but kind of as technology, as society, as expectations move more quickly, mm-hmm. are keeping up with that well enough. And one thing that I find very kind of gratifying in that area is that, so I often speak at conferences for judges to talk about kind of social media and the law of privacy and things like that. And when I first started doing that, when I would ask people who has a Twitter account, who has a Facebook account in the room, you could have 100 judges in the room and only a couple would raise their hand for Twitter and much more for Facebook because they wanted to see pictures of their grandkids.
Right.
But we have seen in the last number of years a significant number of retirements from the bench and a significant number of appointments to the bench. And so they're not quite digital natives, but they're people who, at least through most of their professional lives, have had a computer on their desk and so the number of people who are aware of kind of technology and impact on young people, because if they're in their 50s, when they get appointed as a judge, they have kids who have recently gone through that. So there's, I think, a much better appreciation of these sorts of issues. And I teach internet and media law at Dalhousie Law School, and it's hilarious sometimes to go back to the older cases that are still influential, but where the judge has to kind of explain what the internet is. And now try to find a family court judgment that doesn't include the word Facebook or Instagram.
Right.
And we're just in a different environment. And so I think that they've had to keep up, and they're doing their best. I tend to think that I'm not a fan of just changing laws in order to keep up with technology. I much prefer principles-based laws that are resilient, where the same principle can be used into the future.
One of the things that we preach is principles stay the same, diverse in application.
Yep.
Right? You know what, David? I'm going to go to my closing now. If you just want to hold tight here, I just want to debrief you just really quickly, but I'm just going to end now. You know what? I hope everybody sees why I was so happy that I found David and his expertise. I mean, his knowledge in the field, like unbelievable, right? And what I really like about David, and I'm repeating myself, but is his ability to take the law and put it into an English humanistic approach, right? To help all of us understand this stuff from a bigger perspective. And that's what I really love about his work. And I'm sure that I'm going to be reaching out to him again to talk to him on other topics like bullying and what happened in his province surrounding the provincial statute that came into place and lessons learned and where they are. I think he has got a really good story to tell there as well. So on behalf of myself, I'm Darren Brandon, who's working in the control room, making all this magic happen right now. I want to thank you for attending today's Thinkable Thursday. I hope you got a lot out of it. I did. I absolutely enjoyed this. I just love these types of discussions. So we'll see you next Thursday. Bye, everybody.